inform you firstly that this morning you will need your voting cards, so get them ready, please. Secondly, let me inform you about the decisions taken a while ago by the coordinators. Mrs. Ferrara was appointed rapporteur for the new request for the waiver of the immunity of Mr. Uspaskich. Mr. Chrysogonos was appointed rapporteur for the waiver of the immunity of Mr. Marinho Pinto. It was agreed to hold a joint JURI INTA hearing on transatlantic trade and investment partnership, regulatory aspects and investor-state dispute settlement arbitration during the week of 19th to 22nd January 2015, and to hold a hearing only of our jury committee on administrative procedures in the EU and the US on the very same day. Then it was agreed to keep the delegation to Latvia in January, when only Latvian English interpretation will be possible. So these are the decisions. And we continue our meeting by item 14, amendment of Council Regulation 1346/2000 on insolvency proceedings, and the floor is to the rapporteur, Mr. Zwiefka.
Bardzo dziękuję, panie przewodniczący.
Thank you, Mr. Chairman. Once again, before the vote, I would like to thank colleagues for very good cooperation while working on this regulation. Insolvency proceedings are extremely complex. We touch upon undertakings, but also the employees of undertakings, and that is why the Parliament took on this issue. And we wanted to ensure the right treatment of employees of undertakings undergoing insolvency proceedings. We managed. The negotiations with Council were not simple, but the right approach of all partners of the trilogue allowed us to reach a consensus, and I think everybody is pleased, and especially the Parliament, because we managed to defend our position. And I would like to thank everybody, the shadow rapporteurs and our partners from Council and the Commission. Thank you.
Okay, any comments? None. Then we proceed to the vote. The vote is open. Everybody has voted. Yep, everybody voted.
Too many people voting.
We see that too many people are voting.
A great success.
Yes, and they have too many people. Too many people voting?
Could the political groups check whether their people are well organized?
22. How many should we have?
Can you cancel it and we'll begin from scratch then? So we will try once more. Let's vote once again, please. The vote is open.
Only 21 can vote.
According to Secretariat, only 21 persons can vote, and we still have 23. So basically, there is some problem.
Who was it that came up with it? There are two socialists should not vote. The socialists have a total of 6 members, and there are 8. There are 8 in the room. So two socialists should not vote.
There are 8.
21.
Okay, it's okay.
Okay.
So, okay, I close the vote. Adopted. Thank you very much. Then we have point number 15, petitions on the abolition of early retirement schemes in Hungary. There we vote by showing hands. So, who is in favor? Against? Abstentions? None. Adopted. Thank you very much. Point number 16 has been postponed. We go to point number 17. Unblock to point number 23. And there we use the voting machine once again. I open the vote. Once again, we have 23. The Socialist group should have only 6 people voting, and you have 8 at this moment. No?
Still one too many. 3 Greens? One Green should not vote. Only 2 Greens.
Then with the Greens, everything is okay? Still 23.
EPP?
EPP. Could the one that is not voting, could he or she take out the card from the voting machine?
Okay, it's all right now. It's okay.
Yep. Okay. So the vote is open. Everybody voted. Closed. Adopted. Point number 24. The floor is to the rapporteur, Mrs. Reda.
Yes, thank you very much. As a first exchange of views on the report on the implementation of the InfoSoc directive on certain aspects of copyright, I would like to propose a preliminary timetable today and some background on the report and what we have in mind. I will just wait 1 second. So the InfoSoc directive was adopted 13 years ago with the aim of harmonizing certain aspects of copyright and of responding to the changed digital environment. In this evaluation report, I would like to address the questions to which extent this InfoSoc directive actually has achieved the goal of harmonization in practice in the different member states, and what further legislative steps are perhaps needed to address particularly problems associated with the territoriality of copyright. Aside from the question of whether this instrument has been successful in harmonizing certain aspects of copyright, I want to address where the technological development has perhaps surpassed the expectation of the InfoSoc directive as it was formulated in 2001. Some solutions may seem anachronistic nowadays, for example, when it comes to the rules for libraries and the requirement for people to access digitized archive materials on reading machines in the premises of the library. So the InfoSoc directive directive also makes mention of some technologies, like for example the CD-ROM, that may not be up to date anymore. And of course, in the last 13 years, new uses have emerged that may be creating problems with the current implementation of the InfoSoc directive. Further, I want to look at which stakeholder groups are affected by the implementation of the InfoSoc directive and which specific problems they have reported in the Commission's consultation on copyright. For example, when it comes to barriers to providing innovative services in the digital single market, to accessing works that have entered the public domain, or to clearing the rights for the use of works, so finding out rights holders and to be able to remunerate them. This is a quick overview of the content, what we're aiming for with this report. Regarding the timetable, I plan on presenting a first draft in the mid of January. That would give us, well, this quite short preparation time is also taken into account the quite ambitious timetable that the Commission has set for itself when it comes to presenting a legislative proposal for copyright reform. I would like this report to also inform the debate on the legislative proposal that may already be coming out in the summer of 2015, and perhaps the Commission can give us some updates on the planned timetable for a legislative proposal on copyright. In any case, it is included in the Commission's working plan for the year of 2015. So if we want to have ample time for amendments until February and do another consideration in committee in the last week of February, it would be possible to already vote on the adoption of the report in the JURI session on the 24th of March and have a plenary vote in April or May. Meanwhile, the EPRS is working on a broader impact assessment that is not just looking at the InfoSoc directive but at the entire corpus of copyright, which is expected to take somewhat longer than the formulation of this report, but thereby can take a broader look at the impact of all the different directives that are dealing with copyright and hopefully inform the debate on the legislative proposal that will be presented by the European Commission next year. I look forward to working with the shadows of all the different groups and of course also with the working group on copyright to have an informed debate about the existing challenges with the InfoSoc directive in the different member states.
Thank you very much. So may I open the discussion? Mrs. Honeyball.
Thank you, and thank you to Mrs. Reda for that comprehensive overview. I think it's very useful that we're doing this at the moment, this look at previous legislation and how it's been implemented, because this is a very fast-moving environment, as has been said. And I think that's actually one of the really big challenges that we face in legislating about this, because in just a few years, since 2001, there have been massive changes which have already been pointed out. Digital readers, Amazon Kindle and that kind of thing, for instance, which just didn't exist then. And just the huge changes in the music industry, where music is almost completely now listened to over the internet and downloaded rather than CDs and all the other things that we used to have. So it's a completely different environment now, and I think that's what makes it such a challenge and in many ways quite not only challenging but quite difficult thing to legislate on. So I think this preliminary look at what the previous legislation have been will be very helpful to us, so we can track the technological developments and actually hopefully have a clearer view of how to deal with it. However, I think there are some important principles which we need to hold on to for both this look at the implementation of a previous directive and how we go forward on it. And I think one of the key things is that we need, it sounds very obvious, but we do need proper protection of intellectual property, because if we don't do that, we are just simply not going to have the the music and the books and the audiovisual programmes that we are so used to. If we don't protect intellectual property so that those who work in this sector as creators and performers and authors and artists and everybody else, those behind the scenes who put it all together, if we don't have protection of intellectual property, they will not get paid and they will not work in it. And I mean, that sounds very dramatic, but that is actually the case, and that is why this whole issue is so very important. And I think one of the things that Mrs. Reda talked about, which we need to really take a view on, certainly in the future, is territoriality, because this seems to be becoming an absolutely major issue, and there's a lot of differences within the sector on it. People who work in audiovisual have quite a different attitude towards territoriality than the music industry does. So I think that's one of the big issues. But the key thing that we need to do for this, as well as track the technological developments, is to maintain the underlying principle that we need to protect and improve intellectual property rights.
Thank you very much. Mrs. Comodini.
Thank you, Chair. As Shadow Rapporteur for the EPP, I really look forward to working with you on this report. I do agree with you on most of the items that you have highlighted that this report will need to at least address, not least the ever-changing technology through which these services are going to be accessed. And to be very honest, the first question that came to mind when going through the documentation was really and truly, can we ever regulate in a way that would be applicable, that would apply to the ever-growing technological changes? So, in a way, I think that this report will need to underlie also a couple of principles. We do understand that research and innovation will continue to strive and deepen the growth and the European economy. And I think a legislation of the sort must ensure that it incentivises private investment in research and innovation. It actually protects the originator of the idea, but at the same time it must also make the services available and accessible to users. Any proposals that we have to come up with or that we come up with in this report, I feel must be somehow foreseen to be made applicable to the continuous developments in information technology. But we also have to keep in mind that users, the attitudes of users and the expectations of users to these online services are also continuously changing. And most probably the underlying foundation of this report would be how much of a balance are we going to manage to reach between incentivising research and innovation, that is protecting the originators of the ideas, of the services, the providers themselves, the service providers themselves, as well as the changing expectations and attitudes of the users. I believe this would probably be the crux of whatever proposals we need to make in this report. But I really look forward to working with everyone on this report. Thank you.
Thank you, Mr. Cavada.
Merci, Président.
Thank you, Chair. I'd like to support what my colleagues have just said, in particular what Mrs. Honeyball has said. We shouldn't create the devastating and historical error of thinking that modernizing access to cultural works should eliminate the basic idea of creating an economy of culture. I would like to stress that we are at a historical turning point. There is no culture without an economy of culture. Of course, there's always going to be someone who is going to fiddle around and come up with something and might have some bit of the market. but we would be opening the doors wide to a dominating culture, the English-speaking culture, when I mean American, because I consider the British as part of the European culture. And we talk about free access. Isn't there free access at the greengrocer? Do any of you walk off with his apples without paying for them? No. There is a big major danger which is in the European Commission, and we're not a majority on this, which has to be combated at all costs. We want European cultures. Each country has its own culture. On a continental context, which should be as harmonized as possible, and where access should be facilitated. But there is a major danger here, and I don't want this to be overlooked, because I can see this creeping in over the years. Everything should be free. Yes, everything should be free of cost. No. And in fact, people who say that buy their computers. They don't just walk off with it from the store. So this is a highly political issue, and so political that it's going to affect our democracies, the way our democracies work. We have a political culture, not a cultural policy. We have a policy of living together. We have laws which are based on our cultural roots, and we must absolutely defend this throughout the world. People are watching us. There are two options in Europe, and I'll finish with this. There's the possibility of aligning the content to the pipes, and I'm against that, and I'm not the only one who's against that. We'll have a large majority in the plenary for that. And the second option is to think that, as I've already said elsewhere, that we are like those who own oil in the ground between two world wars. But they weren't the ones who got rich. It was the pipe owners who got rich. We have the content. I don't want there to continue to be this dealing in pipelines. I would like to see fiscal harmonization in all of the continental European countries, so that the market helps the culture and that the tax is paid as it should be today.
Mr. Kester.
Es ist offensichtlich, dass ein modernisiertes Copyright.
Well, it's clear that a modernized copyright system is absolutely essential if we're going to bring forward the cultural industries and promote them. But I think that there's an important aspect that we need to bear in mind here. In the cultural sector, you've got four main players. You've got the creative people, you've got the producers, the traders, and the users or consumers. At the moment, it's the traders, the intermediaries that have the dominant position, and they are the ones that are building monopolies in the digital society. They are the ones who are drawing out all of the profits. And as Mrs. Honeyball has already stressed, we have to bear in mind the creatives. We need to create a copyright system that protects the creators of culture. They are the ones that bring culture into the world. Their position needs to be strengthened by a modern copyright system. That is our task if we are to try to get back to a balanced relationship between the creatives, the producers, the intermediaries, and the consumers and users at the end. So that is the huge task that we have before us. If we want a cultural economy, then we need to be trying to struggle against piracy as well. Copyright is an important instrument in trying to combat piracy, to try and ensure that we have a proper market process in the sector. Thank you.
Thank you very much. Mrs. Geringer.
Dziękuję, panie przewodniczący.
Thank you, Mr. Chairman. I agree with most of what colleagues have said so far. I just want to emphasize one aspect. Culture nowadays is not some kind of niche activity that we have to protect, take care of it for many reasons, among them to maintain one's national identity. Culture is part of the economy. That's where employment is generated, new jobs. We have the cultural industry. And if we are harmonization at a market, the mainstream market is harmonized, but everything that is on the internet is divided up into 28 subsectors. So I think that we should enlarge the territoriality to the territory of the EU. So here we should harmonize our territorial rights, otherwise the digital market will not work. I'm not only speaking about books, about recordings, but also about Xerox machines, tablets, other types of devices where we can download something, copy something. My tablet can be used for copying content, so they are part of the copyright law. So we have new challenges here, and this is closely linked to economic development and to the market. And this is a wider aspect than only copyright aspects that are not compatible with new technologies. We do have copyright laws. They are implemented in member states, but the system does not work. And that is why we have this illegal but very vibrant activity of copying content. So we should make sure that we can enforce copyright, and this is a very important task also in terms of information campaigns. Thank you.
Thank you very much. Mr. Marinho Pinto.
Obrigado.
Thank you very much, Chairman. Well, on this issue, I do have a few opinions that I'd like to pass on to you. I do agree with the basic idea of a culture economy, but I have some reservations about some aspects which I think could be called fundamentalism that seems to be growing around the problem. Well, if you'll allow me to situate the problem, we've got economic benefits that can be drawn from the creation of artworks, Petrarch, Camões, Cervantes, Rubens, Bach, Mozart, Van Gogh, Beethoven. If you go all the way back to ancient Greece, now the question here is that we might be opening the door to a huge problem, which is the making art a commodity. I think that really distances us brings up a distance between the consumers and the creators of the art that's created. If we are basically using economic measures and reduce the access to the public, then I think that what we're actually doing is leading up to a situation where good music and good reading is a privilege for the elites. The internet has opened up huge doors to allow mass consumption of cultural production. I think that this opens up new horizons. It's creating a new kind of person, a more cultivated human being, open to music from all of times and places around the world. You can use the internet to read works that were only accessible in the past to those who had enough money to buy them. I think that what we could do is try to find some kind of point of balance. I don't agree with what Mr. Cavada said when he says that a cultural work is just like vegetables that we buy at the market. If you want to buy vegetables, you have to go to the market. But here we have a situation where cultural works can come to our houses, right to our homes, just thanks to a click of a mouse. Well, I think that this is marvellous. It's transforming humanity, it's transforming the world, it's transforming culture and civilization itself. Let's be open to what is new here. We should create incentives to ensure that people should all have access to works of art through the internet. In the past, it was just the elites that had access to this kind of thing. So we need to spread culture through society. That is a positive aspect. It's something that can't simply be destroyed by commodifying art and cultural goods. However, piracy is a totally different issue, where they are trying to enrich themselves by undue access to a work. Okay, if I want to listen to Jim Morrison or Beethoven or Wagner in my own home, well, it's I would have to pay for it, of course, and I would have to use my computer. But when you make a payment for a cultural work, you have to understand that it's very important for the entire population of the world to have access to magnificent cultural works, whether we're contemplating a beautiful image in a painting, or if we're trying to read books in a form other than in print, and listening to the music that you like.
Thank you, Mrs. Rosier.
Merci, Président. Rapidement.
Thank you, Chair. Now, just to come back over this question, whether or not these cultural goods have got a specific economic value, I think that this discussion, if we look at the amounts of money involved given in this area, well, I think that then we can say that it's clear that these cultural goods have got an economic value. However, I don't think that that means that we should consider them like any other goods, but I don't think it would be right to say that they have no economic value and that they can be dealt with completely without cost. Now, I think that we need to be careful when we're dealing with this question with regard to the status that we give to these cultural goods, and the fact that there's a political value and an intellectual value with regard to these cultural goods that must not be forgotten. Now, of course, we do have cultural goods which are in the public domain and which there are no more rights, and today they have completely free access, but the area of creation, it's not something just dealing with the past, it's ongoing. And in Europe today, we are lucky enough to have a cultural creativity, which is doing very well, and indeed it would be a great shame for us if there were intermediaries who are making a lot of money in this area of cultural goods. It would be a pity if we were not able to protect our cultural area and its sustainability. Thank you.
Thank you very much. This was the last speaker on my list, so Mrs. Reda.
I would like to thank my colleagues for a lot of very important remarks. I think it's very important what the shadow rapporteur, Mrs. Hannibal, said about providing the proper incentives for artists and authors to be able to continue to create. And in this vein, I really welcome that the EPRS is also looking at this question, and I think we have a better basis of data on which incentives actually work. And also the hearing that we have had with experts in JURI has already given us some ideas of how we can address this problem. In the same vein, I absolutely agree with my colleagues Mr. Cavada and Mr. Costa that were referring to making sure that at the same time to ensure access for people to cultural content, but to also secure remuneration. And in this vein, Mr. Costa highlighted that in a lot of cases the intermediaries in the production chain have a very strong position versus the authors. So we should look at how we can strengthen the negotiating positions of authors versus the intermediaries and make sure that the remuneration collected, for example, by collecting society actually ends up with the authors and is fairly distributed. And in this regard, we need to look at the transparency of the collecting societies and also the easy registration of works so that people who want to acquire a license for works have an easy time finding out who the right holders actually are. Further, Mrs. Comodini, shadow for the EPP, highlighted the importance of research and innovation, and I think in this regard the European Parliament has also already made some very important decisions, for example when it comes to open access publishing in the context of Horizon 2020, but I think there are still some challenges ahead, particularly when it comes to copyright, for example, to allow the text and data mining and ensure the competitiveness of European researchers when being able to really use data in a flexible way. And in this, in order to allow this, we also have to look at the database directive and its re-evaluation. I agree it's not just about adapting copyright to the technological changes, but also aiding the Commission in its plan to complete the digital single market. And one of the big problems that is right now existing with territoriality is that it is standing in the way of the transparency of the legal system. So as with the aim of better lawmaking, we really need to make sure that it is transparent for Internet users what is actually allowed and what is not. And having more harmonization across borders is certainly one way of achieving that. So thank you very much for these first remarks, and I look forward to the collaboration on this report with all of you.
Mr. Kavada wishes to say one more sentence.
Oui, pardon, Madame. C'était.
Yes, Madam. There was just information I wanted to tell everyone. The working group on copyright will take place on the 17th of September in the presence, December in the presence of Mr. Oettinger.
Thank you. We pass to point number 25, and the floor is to Mrs. Rosière.
Merci, Président.
Thank you very much, Chairman. Well, I'll be presenting to you the proposal that the Parliament should put together an initiative report on the Commission's Green Paper on possibly extending geographical indications to non-agricultural products. Well, as you may know, the European Union is rich in products that are based on traditional knowledge and production methods. Carrara marble, for example, Murano glasswork, etc. Just to cite a couple. They're part of the richness of the European cultural heritage, and as they're results of this traditional know-how, where they come from a certain place and culture, we find that the fame of these products is often abused by others, and there's losses to be sustained as a result. If consumers think that they are buying products that are representative of local know-how, but they end up finding themselves with a lower quality product where that come from somewhere far distant from where they're supposed to come from. And the honest companies find themselves basically beaten by companies with lower quality levels elsewhere that are abusing their own local geographical indication. For agricultural products, geographical identifications are not an issue. Since 1992, these indications have been protected. However, there is no European regulation that protects the origins of industrial or craft products. Well, a number of member states, 15 member states in fact, have so far put in place mechanisms for protecting geographical indications of non-agricultural products. On that basis, the European Commission has basically come to the same conclusion, and in April 2013 they published a study. The idea was that they would basically take a snapshot of the existing geographical protections, and they came to the conclusion that a system should be set up at the European level. The current Green Paper follows on from the conclusions of that study. The study tells us that the current situation, with 15 member states having specific protections, basically contained huge loopholes because it didn't cover the entire European territory. And it was a very mixed level of protection, because you have trademark protection doing this on the one hand, others in the case of fraud or misleading publicity. So the measures taken by the 15 member states were very diverse, and as a result, some of these are sectoral measures as well, some of them are cross-cutting. So the level of protection is very different in each member state. This system is very difficult to deal with for companies concerned, and in many cases these are small, if not micro companies. So it should be possible to overcome the current situation where they have to pay large fees for protection. I think a European system would lead to major benefits for the companies concerned, but also for our consumers. We need an instrument with a uniform level of protection which would allow us to recognize the quality and origin of products, and that would allow us to combat counterfeit products. It would allow us to overcome the complexity and costs that I mentioned. The craftsmen and producers need to give value to their local products to keep the economic value in their local area, and the employment connected to it, of course. Geographical indications that can allow financial resources to be harnessed that go beyond the abilities of a small or medium-sized company. It contributes to the development of our regions, including in tourism terms. In many cases, these regions are particularly fragile. It allows for protection to be made in the single market with a single level of protection across Europe, and it would allow our producers to help conquer markets outside the EU. The French textile industry has now got an extra 25% of demand thanks to a geographical indication from the European Union. Now, these days we want more traceability. I think it's only legitimate to have further information about the place of production, because there are qualities that are linked to the territories where these products come from. We need to ensure that this is all verifiable, so that consumers that choose a product bearing a geographical indication can do that with a sense of trust. Of course, they don't have any market access problems here. It's simply a question of structuring the current supply on the market, is to allow value to be given to natural and human resources. Well, if you have member states in charge of all this, I don't think there would be a proper respect for the geographical indications. I think it's important that we should have a uniform level at the European level. And I think that that would help us to overcome a number of problems. Well, of course, the first concern would be to set up a single system with a registry at the European level. Registering is important. That means that third parties would be able to oppose or this geographical indication if they felt justified in doing so. I think it's also important that small and medium-sized companies should be protected, but also consumers as well. I think it's a way of providing a guarantee to them. a geographical indication should also be important in this process. They should take the initiative for setting up the geographical indication. They need to describe the kind of characteristics that are required. Geographical indications should set up a link between the product and the geographical area, but that's only obvious. But we also need to ensure that there can be a coexistence between different geographical indications that might have pre-existed the European system. So if we're going to extend geographical protections to these products at the EU, it will allow us to protect our varied cultural heritage. I think it would also be a contribution to creating jobs and growth in Europe. I think you can draw a parallel to what exists for agricultural products which have a single European system. If you look at the French system, protected geographical origins create a huge amount more jobs than the non-protected the dairy sector, for example. If you have the Bayonne ham indication that was set up in 2008, that allowed 1,000 jobs to be created. So about 30% of the jobs created in the sector were partly thanks to that geographical indication. Now, the draft report should be available in January 2015. The deadline for amendments should be 30th of January 2015. The examination of the amendments will be on the 23rd or 24th of February. Thank you very much.
Thank you very much. That's a very ambitious timetable, I would say. So I open the debate. Any requests for the floor? I do not see any. So, Mr. Cavada.
Sans vous faire perdre du temps, chers collègues.
Now, I don't want to waste your time, Chair and colleagues, but this view of things is something I support fully, because this is an area that doesn't receive a lot of support, and the products do really generate wealth and jobs. And so I really do give my full support to this path with regard to this area.
Okay, thank you very much. So I guess the first exchange of views is over on this point. Point 26 has been postponed, but we have some leftovers from yesterday, namely points 8 and 9. And the floor is to Mr. Cavada, the rapporteur.
Now, I'll be very brief. We're talking here about registered partnerships. The situation as things stand is that the Parliament only has a consultative role in this field, and in fact it's Council who decides alone. But for the moment, Parliament's work is concluded. It has concluded the first step. We're now waiting for Council's position, but because we want to show that we're interested in this field, because it's very important for many people, and in particular transnationally, well, we have decided that we want to push Council, and they have to be unanimous with regard to their 25 states. There are some opt-outs: United Kingdom, Denmark and Ireland. I just wanted to say that I do think that it's somewhat curious that those three countries who are not going to be voting will nonetheless be negotiating and participating in the discussions. I think that's a little bit unusual.
Yes, indeed. Mr. Duda.
Szanowny Panie Przewodniczący.
Mr. Chair, I just want to draw your attention to the fact that there are a lot of doubts related to this matter in certain states. I think the subsidiarity rule is very important here. We don't have registered partnership everywhere. There are states where such regimes have not been introduced, and establishing regulations at the level of the European Union, regulations that would be binding for member states, even those where the system does not function, well, this is a bit doubtful. The Senate of Poland and Romania and Italy have already drawn your attention to this fact. Also, the government of my country has made some remarks on it. So I would like you to note this reservation. We would have a very paradoxical situation. States that do not regulate such regime in their own legislation would have to recognize such partnerships if they were drawn in another country. So this would be a bit doubtful.
Mrs. Hautala.
Thank you, Chairman. I have a different question to which I would wish Mr. Kavada to perhaps give an answer. I noticed that the Fundamental Rights Agency has said in its opinion that there is a discrepancy in a discriminatory way in the way married couples and registered partners are allowed to choose the law under which they are, so under the law. And now my question is that how does it look like? Is the Council treating this issue so that we don't end up in a discriminatory situation, that all couples, irregardless if they are married or if they are registered partners, would have the same right to choose the law?
Then for the Italian presidency, Mr. Bruno.
Oui, Monsieur le Président.
Chair.
Que le niveau d'information soit le même pour tout le monde. Voter, c'est fait.
Now, remember, this vote has already been voted on. The only question that could tell us any more is the opinion of the Council.
Buongiorno a tutti, grazie Presidente.
Good morning, everyone, and thank you very much, Chairman, for having given me the floor. Now, the debate in the Council under the Italian presidency has been taking place in two different working groups. I must say the negotiations have not been going very easily. As you've seen this morning, these are issues which are particularly thorny and delicate to deal with. Despite all of this, the Council has been very involved in this work, and we will be presenting a full state of play to tell you how negotiations are going on the 4th of December, that's to say the day after tomorrow. Well, there were a few questions and concerns expressed by the members. All I'd like to say at this point, very briefly, is that the discrimination issues that were raised by some parties, that's to say in terms of copies, have been updated in the new versions of the two texts, and the Italian presidency has put these texts forward as possible compromise proposals. We've paid particular attention to the fact that in both of these texts there are parallel standards which try to safeguard the two different institutions. We have tried, wherever possible, to try and eliminate any form of discrimination or discrepancy between the two different institutions concerned. So, on jurisdiction and on the choice of applicable law, the current version of the two texts, we have certainly been able to remove these elements of discrimination or discrepancy or whatever you want to call it. So that's the current state of play in the Council.
Thank you, Mr. Rajev.
Благодаря, господин председател. Уважаеми решенията по...
Thank you, Chairman. Decisions related to matrimonial property rights and property consequences of registered partnerships are very important for European citizens. With the freedom of movement in the European Union, there are more and more couples living in cross-national couples coming from different countries. There are at least 16 million couples like this, and 650,000 of them get separated every year. And it's very difficult for them to figure out where are the competent courts and what is the applicable law to the separation of their property. International couples trying to separate their property have to figure out applicable law, the competent court, and they also have other difficulties related to recognition and execution of court decisions. There are differences among the member states, and that is why we witness forum shopping, and also we often witness a race to court. And it's not a good idea to have people live in this kind of legal insecurity and also have to pay more when they have to figure out how to separate their property in cases of divorce or separation or death. And I hope that the Council is going to take into account the position of the European Parliament voted in 2013 and the recommendations there, and also the comments on the regulation on inheritance and Brussels I. And it is very important to have in mind that the member states should have the option to accept property consequences, property-related consequences, but not necessarily other consequences of registered partnerships. They are not obliged to create registered partnerships in their territory.
Mrs. Hautala.
Thank you, Chair. I would still like to come back to the Council, because I believe that you're a bit too discreet when you only talk about some parties in the Council. So would you please specify a little bit? I don't think these should be secrets to the committee. And I can see that the rapporteur, Mr. Cavada, agrees.
So, Mr. Bruno, would you add some information?
Thank you very much, Chairman. Well, as I said just now, I would prefer to note that the Council has been putting together a state of play which they'll publish the day after tomorrow. So then you will get a list of the positions of the individual member states, and you'll understand the main stumbling blocks that we've had so far in these very sensitive negotiations. So I would like to basically allow you to see that in 2 days' time.
Pinto.
Obrigado.
Thank you very much, Chairman. Now, I wasn't in the meeting yesterday, but it seems that this is basically a game of trying to chase shadows here. I think what we're talking about here is a fundamental right for human beings. That's to say, the right to choose the partner with whom you wish to set up a life partnership. I think that's a fundamental right for a human being, to be able to get married to whoever they want, to a man or a woman. And it seems that the member states are simply just not following up all of this. With the different forms of family relationships, I mean, if I want to set up a life partnership with a man, then the state cannot prevent me from doing so. That's a fundamental right. I think that we should be discussing these issues openly. This is a violation of fundamental rights when you do not allow them to get married to whoever they want. Matrimonial regimes is something that depends on each member state. These regimes vary from member state to member state, even for heterosexual marriages. Okay, the legal framework is different. So, okay, we shouldn't be starting from the end. We should start from the very beginning. And the principle is this. Marriage is an institution created by a man for political, economic and social objectives, which were very specific and very clearly defined. This can be changed at any moment in their scope or their contents. So, if you say that people of the same sex cannot enter into this legal contract through which they formalise a life partnership is a violation of human rights, a fundamental right of the human being. Marriage can take place in any religion you want, and then the religions can decide on the content. In the Catholic Church, it's a sacrament, for example. In Islam, they allow polygamy in some cases, etc., etc., etc. There's lots of content in different countries. But nobody can deny a man and a woman to choose what partnership they want to enter into a life partnership with. This would be a violation of a fundamental human right. Matrimonial regimes are important. We need to be discussing it, but we need to be looking at it from the perspective of a violation of fundamental human rights. If you say that a man can't marry a man and a woman can't marry a woman, marriage is an institution created by man, and as such, man can change it and cannot use it to deny fundamental rights.
So this is the end of the list. Mr. Cavada would maybe take the floor.
Je vous remercie, Président.
Thank you, Chairman and colleagues. Now, I'd just like to make a little bit of a comment. I hope you don't mind. I think I will ask my colleague, Madame Rosier, to patent a special GI here, geographical indication, with regard to what Mr. Bruno has said. I, in fact, expected that the Italian presidency would make more progress in this area. They are the country that have really examined all of this very closely, and they want to play an active role. But 60 years after the beginning of the common market, now the European Union, we have made many achievements: finance, standards, production, health, but we can't give equal freedoms in an area that is so fundamental, much more so than with regard to carrots, as our colleague Mr. El Pinto said, and others indeed, i.e. the same freedoms for all the member states of the Union, for the people in those member states. Maybe we could try and push those countries that are a bit reluctant to work in this area. Now, that's not going to be too difficult. There are, of course, problems, and I agree with you, but it shouldn't be impossible. This way of working is nonetheless disappointing from the point of view of the Italian presidency, because I really had expected more. But let's not... I don't think we're too surprised that there's some countries that are reluctant. I'm trying to find a way to shake things up. Things are not moving fast enough. We need to move forward with regard to harmonized systems. People can cross borders and they can work, but they need to have these common freedoms. And this is something that has to be tackled quickly. I don't know if Council is planning on starting this on the 5th, and I think that the opt-outs should be also looked at again. We shouldn't be in a situation where we can opt out of obligations that derive from us being in the European Union. Too much laissez-faire. We need to get things moving here with regard to those governments that are slow. Thank you.
Mr. Bruno.
Grazie Presidente.
Thank you very much, Chairman. Well, I'll try and respond briefly to what Mr. Cavada has just said. I don't want to be misunderstood here. The work that's going on in the Council have been taking major steps forwards if you consider the state of play a couple of months ago. Now, we have put to the delegations a possible compromise text taking into account the various sensitivities of the Member States. As you may be aware, these are two files that have to be adopted with unanimity, as Mr. Cavada noted at the beginning of his comments. When unanimity is reached, then steps forward will be taken. But of course we need to be cautious and prudent here. We don't want to compromise the future of these two proposals. In our proposed compromise text that we put before the Member States, there are a whole series of provisions which should clarify the relationship between the national authorities and the regulation. There are standards on the choice of jurisdiction and applicable law. And as I said earlier, we've tried to overcome all of the various discriminations between the different two types of provision. These regulations don't just affect the economic consequences. They don't affect the nature of the basic institutions that underlie all of this. So I just wanted to calm and the concerns expressed by the members this morning that we have been moving forward, and as a result of the progress we've made, we've been able to put forward two texts which are a useful basis for our work. And I think that we can arrive at an adoption of these texts in the